Hello and welcome. In this month's on-demand webinar, OJM Group Principal David Mandell calls attention to an increasingly common mistake made by many physicians in their asset protection planning. It's important to note that this video is for informational purposes only, and the information may not be suitable for your personal circumstances. Please contact a professional before attempting to execute any of these strategies. If you find this information helpful, we would encourage you to check out one of our books. We'll discuss how you can get a free ebook download or hard copy of Wealth Management Made Simple or any of our other books.
Hello, this is David Mandell. So we'll do a couple of sort of introductory, and if you've watched all of my asset protection videos within the OJM page, the OJM channel, then some of these you may see before, but they're good to set the stage for what this mistake is I'm going to talk about. The first thing is, why would you even be interested in asset protection? Well, as a physician, regardless of your specialty, you practice in a relatively high liability job. And the risk that most physicians are most concerned with is medical malpractice. And certainly there are cases that I see in the legal reporters all around the country from time to time that go beyond typical 1 million, 3 million coverage. And so there could be excess judgments that are a risk, and that could be those judgments could be executed against the physician's personal assets. Do I think this is highly likely? No. Do I think it's worth doing some protection against any of these risks in your wealth management plan if it's not expensive or time consuming? Yes, and that's why we're talking today. So there's malpractice. For those of you who are in private practice, you may have employer liability like any business owner like myself who has employees working for us. And this can be a whole host of types of risks, and a lot of those are not covered typically by insurance. You can get insurance, and that's part of at OJM Group, our asset protection analysis is to look at those insurances and see if you could be better covered with some other coverages, but many physicians don't have that. There's billing issues that we see that the practice or even the personal docs as practice owners could be liable for. There's HIPAA violations, seen that more and more over the last 5 years, where there's liability to a practice or physicians because of HIPAA violations. If you own real estate, there can be premises liability, and there's a whole host of personal liability, from driving to signing personal guarantees on businesses, to contractual liability, to liability imputed because of children driving. Lots of different risks out there. And again, this isn't to say that we should be paralyzed of a worry, but asset protection is a field that, a multidisciplinary field, as we'll talk about, that addresses this and can give clients pathways to shield assets in some ways very significantly, in other ways at a decent level, to protect against these risks. If you've read any of our books or even skimmed through them, you'll see this slide. We've had this in our books probably 15, 20 years at this point. I've been practicing law in my law practice for 22 years, helping clients with this. Started with my father, who was a physician who was concerned about being sued back when I was even in law school. And this slide, I'm not going to get in depth on it, but you can see we use a -5 to a +5 sliding scale, -5 being representing assets that are totally vulnerable, no protection whatsoever, +5 representing an asset class that is exempt either under federal or state law, meaning it can't be touched by creditors, and as long as there's no other limiting factors, you could even file for bankruptcy and get rid of a creditor, whether they had $1 billion judgment or a $1,000 judgment against you, and you can keep that asset in full. And so this is how people can really protect assets, is the +5. Those are exempt assets, things like homestead, things like life insurance in many states, qualified plans in many states, IRAs in many states. In the middle of the scale are tools that typically lawyers provide. Ownership forms, like you can see TBE in the middle of that, means tenancy by the entirety in certain states. LLCs, limited liability companies. FLP, family limited partnerships. Certain types of trusts. Those fall in the middle of the scale. They're certainly much better than the negative positions of exposure, but they're not and never could be as good as an exempt asset, which your state or federal law says this is off the table. So when we think of asset protection planning, it's really about moving clients in the significant parts of their net worth from the negative positions to the positive positions. You're not going to get to +5 across the board on every asset class, either at a practice or personally. But depending on your state, we can get a lot in the +5 positions, and we can get a fair amount of what's left in the positive positions through using different legal tools and ownership forms. Now, you should be thinking of asset protection as a process, and I analogize, and I think it's very relevant to think of it like medicine, like a patient coming to you. There's two parts of the asset protection process. There's diagnosis, and then there's treatment. And that's the way we handle it when we see clients at OJM Group. Diagnosis is to analyze either whether we're coming in to evaluate a practice or a client personally. I've done this thousands of times for clients across the country, where we will analyze either the practice assets, accounts receivable, real estate, equipment, et cetera, look at any LCs, get into their operating agreements, do a diagnosis. Where are they today? Okay, on either personal assets, your balance sheet, or the practice balance sheet. And then the process takes it from analysis where you are to give you the options for better protecting those assets. What are the medicines in our medicine case? What are our tools in the toolkit? Whatever analogy you want to use. What can you do to protect these assets? Is it a legal tool? Is it an ownership form? Is it an exempt asset, et cetera? And then giving the client the costs and benefits, pros and cons, just like you would do for a patient. Hey, here's what I think I see based on how you present. Here are your treatment options. Here are the costs and benefits, pros and cons. And then you make a recommendation. That's what patients want from you. That's what clients want from me. They want to understand the landscape, but ultimately they want me to answer the question, what would I do if it was me? What would I do if it was my parents, my brother who's a cardiologist? What do I recommend for their treatment plan? Okay? That's the diagnostic process, and that is crucial, because if you don't get that right, then it doesn't matter what you implement, right? I mean, you can have great medicine, but you're applying it to the wrong condition, it's not going to do the job. Then you go to implementation, and typically there's three types of tools that we even referred back to in the prior slide, of the tools that play a very valuable role, and each of them valuable. And I really can't say one more valuable than the other in a comprehensive asset protection plan. There's insurances. Insurance is your most likely form of asset protection, whether you think of it as your homeowners, your umbrella, your car accident, your auto insurance, your malpractice insurance, any of those, it's your front line. That's where most likely you're going to have your protections come from. Certainly there are claims that are outside of insurance. Certainly there are claims that could go beyond insurance. And some of these liability policies have a lot of exclusions. So we have to go to the next level as well. But insurance is crucial, and that's why at OJM Group, when we do a diagnostic, part of our analysis is looking at those policies by experts who are agents in those policies nationwide. Then we look at exempt assets, and I think those are where you start, because going back to the scale, that's the +5. Meaning if you have a medicine in your medicine bag that actually works, that has no doubt or studies that say otherwise, this works, this is a vaccine for polio, whatever analogy you want to use, you're going to use that first. Yet I'm surprised, and I think I tell you why as you come to the mistake in a minute, why so many physicians who say they're interested in asset protection are poorly exposed, or sometimes not exposed at all, in their balance sheet to exempt assets. It's because they think of asset protection as just a legal discipline, and maybe they get some insurances because they just think they going to have that. They don't even think of it as asset protection. And they say, oh, I got to go to a lawyer, and the lawyer sets a bunch of legal tools like I used to do when I was practicing law full time, but I ignore the exempt assets because I'm not an expert in qualified plans, or not a real estate agent, so I can't bring you a home in Florida that's exempt, right? So or a life insurance agent that's exempt in 20 states. So legal tools make sense, and they are third, but I always start with exempt assets because nothing can protect as well as that. Then we get to the legal structures, and the reason I use those third is those fill in the gaps where exempt assets can't help you. In some states, like, for example, California, where I'm still a member of the bar, there really isn't a lot in the exempt assets. Pretty minimal homestead, minimal protection for life insurance, some protections for IRAs, not great, better for qualified plans. So for physicians in California, a lot of their asset protection is going to be legal structures. Compare that to many of the other states, especially on the East Coast, where you have good exemptions and some good ownership forms. You may not need as many legal tools. Okay? But all three of these make sense. And where I see mistakes happen, beyond one I've already mentioned, which is not using exempt assets as much as you should, the mistake I'm addressing today, which I see more and more often, regards these legal structures. And here's the mistake I'm seeing over and over again lately: not using an attorney to draft and maintain legal structures. Okay, I see this increasing in use for two reasons. One, I see some physicians using like LegalZoom or some kind of online provider, which has its role in the world, but I don't think that role should be played by a physician. It should be played to help physicians with asset protection. And then there's a very popular medical conference sponsor who speaks. I was actually at a major national conference in Chicago last week, and they did a lunch presentation. They spend a lot of money to do that. I'm not going to name them today, okay? But both of these outlets, they hire some lawyers inside, okay, to draft the legal documents, et cetera. Whether it's, for LegalZoom, could be anything from a lease to your will, to et cetera. And the sponsor has the same, probably has some attorneys on their website. I think I saw one out of 30 people. But they're not your lawyer. And that's really crucial, right? So just like, I might want to go to Kaiser if I live in California for my medical treatment, but I'm actually going to have a relationship with a physician at Kaiser. And I'm going to have a physician-patient relationship that's not only protected in many ways legally, but I have someone who's actually experienced and an expert diagnosing me and overseeing my treatment. I don't have a receptionist at Kaiser or a billing person at Kaiser as my physician. Now, when you use these outlets, you are your own attorney. In fact, the popular medical conference sponsor changed their website recently, but when some other clients or prospects had come to me in the past, other physicians say, hey, what do you think of them? I would often, as part of my response, just link them back to their own webpage where, in the disclaimer section, I don't see that anymore, it just basically says if you're hiring us, you act as your own attorney. And that's clearly the case today because you're not hiring an attorney. There's nobody there representing you. The other big problem is you get cookie cutter plans. So all the diagnostics are exactly the same. Can you imagine if every patient you see every day, all day, every week, every month, every year, you gave the exact same diagnostic and treatment plan to? Nothing was state specific. Now, they may have that in LegalZoom, but what I've seen of this medical conference sponsor, specifically in asset protection, I've seen their blueprint for both the New York clients, for clients in other states, and they look almost identical. Okay, that's not surprising because that's their model, is to make it, well, I'm not even going to say less expensive, which is my last bullet, but sort of cookie cutter or machine line, or whatever analogy you want to use, assembly line, where people who aren't attorneys are answering the phone, handling the relationship, and they can give you the same, basically, a plan every time. It's very easy to do that from a business point of view. Otherwise, you got to have judgment calls, and that's where you need lawyers on the front line, just like physicians versus something that wasn't that for medical advice. Now, what's the benefit of doing this? Well, I think for some people it's cost. I mean, certainly you can get a will on LegalZoom cheaper than you can if you pay a lawyer. But then the question is, what are you trying to accomplish, and is it worth the price, right? And what I tell clients, just as an example, if clients hire OJM Group just to do the diagnostics on asset protection, they work with me because I'm the expert on our multidisciplinary team. We charge in the neighborhood of $1,500 for that full diagnostic. That could be a 10, 15-page write-up, and then we're giving them pathways, including attorneys I could refer them to, and we know what they charge, and it's not much, and it's usually almost always a flat fee in this area. Okay. So it's not that clients are really saving money. They might on the legal zone, but I don't think they are in this sponsorship. So I'm going to give you an example of this asset protection sponsor and a client that came to us after they had hired them or bought their package, I should say, and I was able to look in depth at it as I have for other clients. So this was two physicians in New York. They're a couple. They were concerned about asset protection. They saw the talk at a conference, and at this conference, they're basically pitching a flat fee, I think $6,500, for a bunch of legal documents, for the diagnostic blueprint, and some maintenance to that. Is a monthly fee. But one of the things I don't like about it, as I've heard back from physicians, is it's very high pressure, meaning you have to pay today, you have to join today, or the price, explodes. And you can put money down, and then you have 3 days to potentially change your mind. And I've talked to a couple of docs who said, I came home, I talked to my lawyer said, you shouldn't do that. It's not going to be relevant for our state. They tried to get their money back, and they have a lot of difficulty in doing that. I talked to one physician, in fact, who had to challenge it on his credit card, then cancel his credit card. So that's a whole other issue. So when I looked at the actual diagnostic, what they call the blueprint, it was virtually the same for this New York City client as it was for other very different states. New York, in every state is different in terms of their law, and New York City is especially different than other states. New York City taxes, have different rules on S corps than any other state. New York City buildings have different rules, and that played out for this client. So as an example, this client had a home in New York City, a co-op, and they owned a couple of other New York City co-ops and condos and a Pennsylvania property, which they rented out. Yet their blueprint was the same exactly I had seen for other clients in other states, where they got a bunch of Utah LLCs, that were formed for them as part of this package for their home and for the New York City and Pennsylvania properties. Well, I'm still a member in the bar in New York, and I used to practice at a law firm on Park Avenue in the city for 8 years. So I know how it works there. I have intimate knowledge, and I can tell you that you'd be rare to find an attorney in New York, and actually in most states, who believe that an LLC is going to be a protective for your primary home, because it's not a business asset. You can't really argue that it is, et cetera. And if you are going to have your LLC own your home, they didn't answer in their paperwork, and I asked the client, did they tell you whether you now need to pay rent to your LLC? Because if the basis of the protection is that you don't own it and the LLC owns it, which would be as if many of you may have that in your practice real estate, well, then your practice, your PA, needs to pay rent, because why would an LLC, a separate entity, a separate person under law, give you free rent? They wouldn't, and that would apply to your home. So now you're paying rent to the LLC. Is that going to have to pay income tax on that entity? Is it disregarded? If it's disregarded, it may not have as much asset protection benefit. Then how do you deal with the bank? Meaning, this client had a loan on their home. They had some mortgage. It wasn't paid off. Are you going to tell the bank that you're doing this? If you are, they're probably going to refinance. You're going to have to refinance at a new rate, and likely the rates have gone up, and they might even charge you a business rate because the LLC is owning it now, not you. So now you're paying a lot more in interest. You may have refinance fees and costs. It may cost you, thousands of dollars to do that, not to mention maybe thousands or tens of thousands a year in additional interest. And this wasn't answered, and most attorneys don't feel like it's very protective. But yet they just got, as part of their package, a big bunch of documents, including a Utah LLC for their property in their home in New York. Secondly, they got a bunch of Utah LLCs for their New York rental properties. And again, I can tell you, as someone who practiced law in New York and actually sat there and worked with clients on a daily basis for 8 years, Manhattan co-op buildings are not going to let you put a co-op in any entity other than maybe a living trust in many buildings. I don't care what entity. I don't care if it's a New York entity. Okay, but absolutely, they're not going to let you put a co-op building inside of a Utah LLC. Okay, so let's just assume that I'm wrong, and the building will allow you to put the building, the property in an LLC. Well, if it's Utah, they're going to have to file to do business in the state of New York. Well, if they file to do business in the state of New York, that's a New York publication fee. Could be anywhere between $1,000 and $1,500. That's New York state fees. You probably need a New York lawyer or some kind of registered agent there. And so now all of a sudden you paid this non-lawyer entity for their cookie cutter plan, and you paid a bunch of thousands of bucks for the Utah LLCs, and now you're going to have to pay somebody local to file them and maintain them in New York. Okay, so as I told, and the Utah law, which is the reason this entity says to the clients, to the docs, hey, Utah has the best LLC law. Again, that's arguable. Most attorneys would not agree that Utah is one of the better states as opposed to Nevada or Delaware, Ohio, or Wyoming, et cetera. But even if it does, now you're paying two state fees because you got Utah and New York rather than one. You would have been better off if they had just hired a New York lawyer and just done a New York LLC from the beginning. So as I looked at all this stuff, my message to them, unfortunately, as part of my diagnostic process was, you pretty much got to throw out everything they gave you. And if you really want to have protection for your home, here's a couple of ideas for that. If you really want to have protection for your New York properties, here's some ideas for that, including I could refer you to an attorney at a firm in New York, wrote a book for New York physicians who can actually help you, like they help hundreds and hundreds and hundreds of other people in New York with rental properties. This is not rocket science, but for some reason, physicians get pulled into this, what they think is a cheap solution, and unfortunately, they end up paying $6,500 and they had to start all over with a New York attorney. So I'm giving you all of this as a warning to say, if there's something, if you're going to get legal structures done, if you're going to get anything done legally, my advice is to do it with an attorney either who has a national network and they may be based in another state, but they have local people to help them with state issues, okay, so they can help clients, or you work with an attorney in that state. So your best practice, in my view, is just like medicine. Look at diagnostic and treatment. And from the diagnostic, this is important too, you can work with a group like us because we're multidisciplinary. Meaning when I map out a plan for a client, it involves insurance, it'll involve exempt assets, it'll probably recommend legal tools, and we're going to either work with your attorney or find you someone that is licensed in that state to create those entities or work with you on those entities, okay? Or you can engage an attorney with vision. And what I mean by that on the diagnostics is most lawyers, unfortunately, even if they're very good at what they do, okay, they will only recommend legal tools, one, because it's all they understand, okay, it's what they're licensed to talk about. And if you're skeptical, you could say that's what they get paid to do, meaning they're going to recommend something that they have in their hip pocket that they can sell you, okay? But we have a lot of surgeon clients, and I got something that was mentioned to me by a surgeon who said, when I started practice, and he's been in practice 20, 30, 40 years, 30 years probably, in his sort of 60s at the end, he said, when I started my practice, I got very good advice, which is you get the best recommendations from the patients you don't recommend surgery for than the ones that you do. Meaning, if I go to a physician and they actually say, hey, you don't need that, I feel really comfortable. I feel like I can trust that person. So if I need to come back and they say, yeah, you do need that they're actually recommending something that is in my best interest. And they're not biased because it's something they're good at doing, right? The attorney is great at drafting trusts, but if you don't really need that trust, why should he recommend that to you? So there are some attorneys who have that kind of vision. I'm privileged to know a bunch of them, and I try to recommend clients to go to them where they'll say, no, you don't really need this complicated legal structure. All you need is X. Or you know what, you would be better off by doing an exempt asset or putting your money in your home like here in Florida and building up exempt wealth that way. So if you can find somebody who is knowledgeable and good at the legal tools but sees beyond that, what I call with vision, to look at all the different options for a client, that's great. And that's what we try to do at OJM. Then once you've got your diagnostic plan, meaning when I do my diagnostic plan for the client, that's what they paid us for, the diagnostic, they can go put that treatment plan in with anybody. They can work with either us, we're licensed insurance agents, if that's part of it. They can put in the exempt assets if that's part of it. They can use either their existing attorney, and a lot of times I'm talking to a client's existing attorney to make sure they're charging the right fee. They know what they're talking about. They're going to help move the client into those right structures. So again, think of it diagnostic, think of it implementation, and if you have the right approach, I think you can avoid some of the mistakes I've seen many of your colleagues make by finding a solution they think is inexpensive and simple, maybe. But in fact, it's not applicable to what their situation is because it's not unique to their situation or even their state. And they end up frustrated because they paid for something they can't either use at all or use to the degree they thought they could. So this is a good warning. I hope you guys absorb it, and I wish you luck. And certainly we're here to answer questions and about asset protection or any of the other areas that we cover in our videos on this channel. Thank you for listening.
OJM is a multidisciplinary wealth management firm, and we've worked with over 1,000 clients throughout the country. We work in 3 different divisions for our clients: investment management, consulting, and insurance benefits. We would welcome the opportunity to speak with you about how we might be able to bring value to your wealth planning. As I mentioned at the beginning of the webinar, our principals have authored several books, all of which are available to webinar viewers at no charge. You can get a free hard copy or ebook download for Kindle or iPad by texting OJM Web to 555-888. You can also visit ojmbookstore.com and enter the code OJMWeb at checkout. In addition to a free book, OJM Group also offers webinar viewers a complimentary consultation where we can answer your questions and see if our firm might be a good fit for your situation. Visit ojmgroup.com or call 877-656-4362 to schedule your free consultation. Enjoy the free copies of our books, and we hope to have the opportunity to speak with you. Thanks for watching.